um, 165 of Article 4, it says that any matter certified by the court as raising a substantial question of law under clause 3B or D shall be heard by an even number of judges, being not less than 3, assigned to the chief by the Chief Justice. Now, before the Chief Justice appoints the Chief Judges, he takes into account the number of things filed. You take into account the experience of the judge that is appointing. You take into account things like whether it would probably bring a conflict of interest. You take into account whether there would be objections from certain individuals and so on, but you not expect to do that at all. It takes into account a lot of things. It's not just an exercise where he writes down the names of judges immediately. He takes into account a lot of things before he appoints the one and so on. Now, in this particular case, Your Honor, this may not have, it's not power that can be delegated. The Deputy Chief Justice it is specifically and expressly delegated to the Chief Justice. Now, with the new technology we have, the Chief Justice happens to be out of the country. There's nothing that stops an individual or the regulator from getting in touch and explaining to her that look, we have got this matter coming up. There is the issue of appointing 3 judges to here. Can you have your views? And they would probably say that, look, why don't you have so and so, so and so, so and so, so and so, and you would actually assign the judges to hear such matters. I would emphasize, and I also keep myself with my friends, that there has been miscarriage of justice. The Deputy Chief Justice should not have done what he did at home. Not that you are put anything against her. Not that you are alleging that there is something that she did which is not, she should not have done. There is also the issue, Your Honor, when you're dealing with matters of this kind in law, the issue of perception. Perception is important. When a Chief Justice performing, a Deputy Chief Justice performing such a kind of job or exercising such a power, what perception are other people calling together? They may read a lot into what she has done. It may be correct or it may not be correct, but there it is. They may come to the conclusion that look, the Deputy Chief Justice probably is acting under direction of the executive, under direction of the President. That may not have been done, but that is a possible perception. It sends the wrong perception to people. And when you are giving matters to do with the administration of justice, perception is important. What signals are you sending out? And in this particular case, a matter involving the Deputy President of the country is being removed under suspicious circumstances. Is it wrong people to suspect that the Deputy Chief Justice was probably preferred instead of the Chief Justice? Is it wrong people to probably to the chain when they're having their first kind of dealings that the Deputy Chief Justice is possible that the Deputy Chief Justice is taken because he's a friend of the executive and such things are so. So to make sure that we do not have such allegations, we stick to the law. We stick to the Constitution. So I emphasize before I sit down that what has happened is wrong, must be condemned, and we should uphold the submissions of my able-learned friends. There is a word somewhere, I think in the Constitution, that the Deputy Chief Justice may perform functions or the duties of the Chief Justice in her absence. Clearly, that refers to cases where the Chief Justice may be relieved or the Chief Justice may be sick or the Chief Justice may be involved in something that is cannot yet perform the work and so on. Now, in this particular case, nobody has alleged to the Chief Justice for anywhere. Nobody has alleged to the Chief Justice on duty, and nobody was alleged anything that made it impossible for the Chief Justice to carry out her duties at all. Again, I'm sorry to pass it down, Your Honor. Removal of the Deputy President has stopped everything. And it's something that is making a number of Kenyans entertain us for interesting things and so on. Yesterday, I think it was on Sunday, was when I was sitting in my house, I decided to listen to the word of God on TV, and I sit down. I decided to listen to the word of God from a lady preacher, and she was saying that what is going on now? God no longer has any confidence in the current account. Now, you can't blame us when such things were happening. You can't blame us and come to the conclusion that the Almighty God and Lord Jesus Christ no longer supports the current government because of such things as well. I ask you very strictly that you have full submission of my friend, Mr. Kibe, and his care colleagues. They are able submission, and it is a beautiful thing.
May it please the court, we will try on the side of the respondents to be precise and concise. Let me start off by thanking Dr. Ogada and Mr. Ongoya for their very kind remarks about the small role I have played in the development of our constitution and law. Thank you very much. I also want to thank Council for the civility that has been observed in the presentation of this matter, and I do hope that the respondents will also remain civil so that we extend the proper respect that the court deserves. I am instructed by the Honorable the Attorney General, a very eminent Dorcas Oduor, our first female Attorney General, and she instructs me to inform the court that she is here because Article 156, sub-article 6, enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And the people of Kenya, they also have human rights. I agree with my learned friend, Mr. Ongoya, who is a very eminent constitutional jurist and a practitioner of the constitutional law. I agree with him when he says the Constitution 2010 in many ways is transformative, has introduced more versatility in the protection of human rights. That is true. I also agree with him when he says that the Constitution must be construed in a manner to give full effect and protection to the rule of law and to human rights. But I further submit this, that the Constitution too must be interpreted so as not to create an absurdity. The Constitution must be construed so as not to create an absurdity or to put it in conflict with itself. What is the purpose of the Constitution? To establish the state. What is its further purpose? To provide for democratic government and to protect the rule of law and to protect human rights. These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power. What a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, and if I may say so myself with a bit of humility, I was one of the drafters. knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute. And I think I will leave my learned friend, Mr. Gobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say, only they are entitled to ex parte orders. They are here to complain that they went before Judge Bongo, they went before Judge Mwita, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lord, I want you to remember, because it is in your file, the transmission from Ongoya is in the portal, unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, good evening, kindly find attached the document for your attention. It has a type to the Chief Justice. It is on the 18th, and it is 15:45. It is 3:45 in the afternoon. So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend will continue.
Thank you. My notes, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself a lot to the powers of the Chief Justice under Article 161, (2)(a) and B, that establishes the office of the Chief Justice as head of the judiciary and of the Deputy Chief Justice as the deputy head of the judiciary, and conversely, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond peradventure, and again quoting from the CTS, that while counsel submitted that there may be instances of delegation, they ignored, my lords and your ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the laws of Kenya. The Judicial Service Act expressly provides, my lords, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. And also the CTS and Banana friend Professor Gilmugai referred to this. There are only 2 professors senior counsels here, so it must be correct. And not in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be a way to Geneva, Switzerland, and Milan, Italy, between the 12th of October 2024 and 24th of October 2024. That is it's in the banner. It's on record. It's on record. Senior counsel and my pupil master coordinated.
Keep your voice
Which is the banner.
Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the contract.
It is.
Or whether it is.
That's why I was asking. You taught me to submit
And politely.
You taught me to submit clearly, and I am polite. Yes, I was a student. And also, and your leadership. It is
It is
therefore
important that in my address to the court, I indicated that the respondents in that application did not file any replying affidavits, through which this material could then be introduced before you.
My lord, it is part of the record. The record.
The material which is in the court portal is part of court record.
Your Lordship,
If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Your Lordship, there's
Mr. Degwa,
Just for good order, my lordship, we make progress. Then we know, because we access the portal through particular case numbers. In which case file is this material available, that we can just log in and get to it.
my lord, it is not in my place. We start educating, demonstrating my and friends what files to do. Because this is the portal. I would have had no other way of accessing.
Professor, can you just give us a reference
Yes, I
for purposes of clarity?
Yes, my lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024, a transmission from Wanyama, and E014 as consolidated. We have this material, we are aware of it. We have even gone further, my lord, and served or passed on the communication to my land. It is the public domain, my lord. We could not have secured this communication anywhere else.
Sorry, do you mean to say that what you're holding is filed on CTS?
It is,
Does it have a date and
yes.
time?
It is in the, what I have here is a copy from the CTS, the reference of the Chief Justice Office.
Are you able to tell
We only accessed it from the portal.
We are requesting
Yes.
I request us straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number which it was, we would have verified it. The other option would have been for my colleagues who are reacting a particular application this afternoon, have they filed an affidavit on this document? Truth of the matter is that documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have a similar timestamp. We're just saying, show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you're asked to authenticate. You do precisely that, you authenticate.
My lord, I can confirm that it is even the physical file. This document, the physical file. So that my land and friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a process we felt. My lord, if I may raise into my time, they will have time to respond. Yes, the judicial portal. I can proceed.
My lady, I have a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made, there's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn, but more importantly, in which case file is this internal memo so that we can authenticate. That's simple. My colleague Dan will say it is in the portal. He has a duty to furnish us with the particulars.
We have indicated, my lords, that it is in the physical file. My life friend is in the module specifically addressing them so that I can proceed.
Your Lordship, would you kindly give us a ruling on our objection?
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a recommendation.
My Lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management arises. And the need for expeditious disposal of the application before you cannot be overstated. My Lords and Your Lordships, time and again, my friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Because, no doubt, my Lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms. My Lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My Lord, what we're dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my Lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. The next phase, my Lord, would be dealing with the question of the next step. My Lords and Your Lordships, it is clear that my friends do not want to proceed with that phase. That is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceeding, my Lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Act. You opine, my lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you.
My Lord, my ladies, as a follow-on to the submission by my two learned senior colleagues, I wish to respond further to the application as follows. There has been a lot of water under the bridge since we convened, or since this court convened at about 11:15 or 11:30 this morning. But as I am no doubt members of the court will be able to quickly figure out, the single issue that is before you is a challenge as to the regularity of this, of the referral of the 3 or 4 matters to this bench by the Honorable the Deputy Chief Justice, the Deputy Chief Justice of the Republic of Kenya. And I wish to commence my response to that objection by saying as follows. The Chief Justice occupies 3 distinct constitutional offices. 3 separate and distinct constitutional offices. First, the Chief Justice, by dint of Article 161, Sabbatical 2A of the Constitution of this Republic, is the head of the judiciary. By dint of Article 163(1), the Chief Justice is the President of the Supreme Court. And by dint of Article 248, Sabbatical 2E, the Chief Justice is the chairperson of a constitutional commission established under Chapter 15 called the Judicial Service Commission. Members of the court, I wish to take just a moment to demonstrate how the Chief Justice is deputized in these 3 distinct constitutional offices. In respect of her capacity as the President of the Supreme Court, Article 163, Sabbatical 1B is clear that the Chief Justice shall be the President of the Supreme Court, A, and that B, the Deputy Chief Justice shall deputize for the Chief Justice and shall be the Vice President of the Court. That is the first constitutional office. The second constitutional office is the head of the judiciary, and I will come back to Article 161 in a moment. Suffice it to say that it is in Article 161, Sabbatical 2, that the office of the Chief Justice is established. And Article 161, Sabbatical 2 states as follows: there is established the office of the Chief Justice, who shall be the head of the judiciary. I will come back substantively to 2B in a moment. But it is important that for the purposes of the commission established under Article 248, Sabbatical 2E, the Deputy Chief Justice is then not the vice chairperson of that commission. In the Judicial Service Commission, the DCJ does not deputize the Chief Justice. Now, it is our position for the respondents that Sabbatical 2A. That is not the President of the Supreme Court. That is not the chairperson of the Judicial Service Commission, but that function is exercised by the Chief Justice in her capacity as the head of the judiciary. It is our submission that therefore the Deputy Chief Justice, who is the Deputy Head of the Judiciary, by dint of Article 161, Sabbatical 2B, can exercise the function of the Chief Justice as Deputy Head of the Judiciary. And members of the court, Article 161, Sabbatical 2 creates 3 positions: the Chief Justice, the Deputy Chief Justice, and at Sabbatical C, it creates the office of the Chief Registrar of the Judiciary. Now, the Chief Registrar of the Judiciary doesn't deputize the Deputy Chief Justice, but the Deputy Chief Justice deputizes the Chief Justice. That does not require any interpretation. That is really comprehension as a matter of English. It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Conchela is good law. And the facts in Lina Conchela are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Conchela was the Chief Justice. The only respondent in Lina Conchela was the Chief Justice. If for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Conchela, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 165.4, then going by the argument, then there would be nobody to empanel the bench because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my lord, it is our submission, or it is our position, that the Constitution of this Republic must remain elegant, and it must remain functional. Interpretations such as the one urged by my learned colleagues for the applicants, that would lead to that sort of an absurdity, should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And my lord, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, subarticle no doubt that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your environment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicant, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, subarticle 4, you are unable to deal with those matters. So, my lord, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with cost, so that the important substance in this matter can be determined by the court. I'm most of that.
My lords, my lady, permit me to just conclude with giving a bit of a context in the Conchela matter. I'm not going to explaining anything because, my lords and my lady, the decision speaks for itself. The decision is a decision of 5 judges of the High Court. In particular, my lords and my lady, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165.4 of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my lady, that is the absurdity that learned senior counsel, Professor Rigathi, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by your Lord, their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business these submissions is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Muja Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday, 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter partes hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024 before the court in Nairobi, and E015 of 2024 in Ongoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my ladies, that prayer was not granted. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mongo and the Honorable Justice Waita in the Nairobi matter. Again, my lords and my lady, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of 22nd of October 2024. And why this is important, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice.
When they get another order in Nairobi, it is okay, there's justice. When we get an order merely certifying our matter as being urgent, then there's, all hell breaks loose. And we're saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my lady, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that the court to have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court, because the people in this court are fully aware of the rules governing the conduct of matters in this court. My lords, allow me a few more minutes just to point out a few other areas which then would speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward, or the Honorable, the Deputy Chief Justice did something that is untoward. My lords and my lady, at paragraph D, the respondents in the application say, subsequent to the reference of the matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that would be something that would come from a party not represented. But a party represented would certainly be talking to an audience other than this audience. At paragraph G, my lords and the ladies, they say they now have a direct accusation on her ladyship, the Honorable Deputy Chief Justice, say that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders had been issued against the government of Kenya and its organs, namely, there is no such order that came from, and a perusal of the file would speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And if anything, this same bench is a bench that has been constituted by the Chief Justice herself. Questions that we ask ourselves: why is it that when we appeared before this very bench last week on Tuesday, on the hearing of their own application, we sat up to midnight? Today, because it is the issue is on the other side, it becomes irregular. That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of the Constitution. And that's why it's important for us that we deal with them. As we seek to deal with them, the only way that the rules of this court establish is that we make an application. My lords and my lady, I look at, finally, I think, their ground number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That I think has been spoken to. My lords, my ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now. We would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her ladyship, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My lords and my lady, I repeat that submission is meant to achieve 2 reasons, and 2 reasons only. 1, to delay the proceedings that are before you today, we have an application, and at the right time we'll be seeking and insisting to have it heard. And number two, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and my lady. My name is Ongoya. I need to submit only on 2 points of law which were actually articulated in support of the application. And these were that the proceedings before this court touch on the Bill of Rights, and they are vitally important that we should actually not be seen to flout the Bill of Rights. The Bill of Rights is chapter 4 of our Constitution, runs all the way from Article 19 to 50. But I wish to remind the court that the Bill of Rights applies to every party that comes before the court, and it's not just one party. The proceedings we have before the court are very important to the petitioner. They are equally important to the respondents. And it goes without saying that over 50 million Kenyans actually have an interest in these proceedings, and this is the reason why the agency has been certified both ways. My judges, aspersions have been cast on the bench so as to call for this recusal and application of Article 165(4), that you're being drawn into a conspiracy to commit injustice because there is no emergency that requires you to hear this matter as a matter of emergency. Far from the truth, the two applications that are before you to set aside the conservatory order are as important as the applications that led to the granting of those orders. Therefore, the hearing of those applications must be speeded up, and we are able to move with the matter ahead. You've also been accused of being enlisted in service of the violation of the Constitution. Again, far from the truth, because this is an allegation being made against you, while the position of the respondents is that justice must be served expeditiously and as required by our Constitution. Finally, Article 165(4), which uses the word assign and not appoint. Inasmuch as this is a constitutional responsibility for the Chief Justice to assign, it is purely administrative. The word used is not appoint. We are using other words like empaneling and what have you. But, sorry, the word used is assign. And therefore, if the Chief Justice is not able to assign, nothing stops the Deputy Chief Justice from making the assignment. That is number one. Number two, where it is expressly provided in this Constitution that in the absence of the Chief Justice, the Deputy Chief Justice will act, relates to Chapter 9, when the Chief Justice is dealing with the executive. In this particular instance, we are dealing with a judiciary where the head of the judiciary is the Chief Justice, deputized by the Deputy Chief Justice. So I also urge you to find that in fact, there was nothing wrong with the Deputy Chief Justice in the absence of the Chief Justice assigning the judges who were to deal with these two applications that were before them that particular day and the next applications which had been filed previously. Thank you.
My Lord, in 2 minutes, my Lord, as you retire to consider the application, Milimani is my name, my Lord. I would invite you to consider Article 259, my Lord, Sub-Article 3, and particularly, my Lord, B and C thereof. And if you allow me, my Lord, I will read it out. And it says that every provision of this Constitution shall be construed according to the doctrine of interpretation, that the law is always speaking, and therefore, among other things, B, any reference to in this constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing, my lord, underline, otherwise performing the functions of the office at any particular time. My lord, it's not disputed that the CJ was out of the country and that, my lord, the DCJ was performing the functions, my lord, of the CJ at that particular point in time. And my lord, our attention have been drawn to the communication from the CJ that had particularly asked the DCJ to take charge. My lord, therefore, Article 259 3B provides an answer to the question that is before you. And my lord, lastly, I'll read Article 259 3C, which reads, my lord, and it says, a reference in this constitution to an office, state organ, or locality named in this constitution shall be read with any formal alteration necessary to make it applicable in the circumstances. My lord, the circumstances before you were that the CJ was not available to give the directions or assign the bench. What the DCJ did, my lord, was applicable in the circumstances. I invite you, my lord, to refer to that provision when you'll be making your ruling. I think.
My lord, I send the Speaker of the Senate. My lord, allow me to make very brief submissions without repeating what my colleagues have said. My lord, allow me to start by quoting Article 145, paragraph 7 of the Constitution, to just contextualize the reasons for our application on Friday last week. My lord, if you look at the provisions of Article 145, paragraph 7, although the impeachment of a deputy president is a serious national stability matter, although because after a vote by the Senate, in accordance with Article 145(7), the deputy president, it says at least 2/3 of all members of the Senate, when they vote to uphold any of the impeachment charges, the president shall cease to hold office. In this case, as contextualized, the deputy president, the former deputy president, in this case, Mr. Rigathi Gachagua, ceased to hold office. My lord, look at it also in the context of Article 22. My lord, this former deputy president, in exercise of his right in the Bill of Rights, my lord, moved the courts by way of a petition. My lord, on Friday, that 18th of October, 2024. My lord, conservatory orders were issued, which, in accordance with the petition, with the respondent's perspective, appear completely problematic. And my lord, they required immediate intervention in terms of the respondents, my lord, moving the court. Because, my lord, the flip side of Article 22 is that whereas you have a right to file a case in court and seek conservatory orders in accordance with Article 23, paragraph 3A, a conservatory order which is discretionary, it means you are suing a respondent. Well, that respondent equally has a concomitant right to move to court, to interfere, to set aside, to ask the court to vary that conservatory order. My lord, the grant of that conservatory order is discretionary. So, my lord, there is nothing cast in stone in terms of the respondent, my lord, coming to court to make an urgent application for the setting aside of that conservatory order. My Lord, there is also nothing strange for the court in public interest. My Lord, for the court in public interest, having looked at the grounds of this application to set aside these conservatory orders, my Lord, for the court to apply Rule 3 of the Mutunga rules, my Lord, to make a just, expedient, and my Lord, proportionate decision in terms of directions on how to dispose of this matter. My Lord, again, under Section 60 of the Evidence Act, we all need to take judicial notice of the fact that, my Lord, now we have the e-filing system. My Lord, when such extraordinary matters come to court, my Lord, the court is empowered. My Lord, at any time, my Lord, at any time of the day, my Lord, at any time to access the system, and my Lord, to give appropriate directions for the expeditious resolution of this dispute. My Lord, they benefited from these orders on Friday. My Lord, unlike them, my Lord, we had the courtesy, because my Lord, we saw the court orders in the social media, and we responded accordingly. But my Lord, unlike them, we were courteous enough to serve the orders which were issued by this court to the respondents. So it cannot lie in the respondent's mouth to say that they have been ambushed to come to court to the extent that they come to court and say that we are acting under protest. We did serve them with these court orders. And my Lord, on the last aspect of that point is that, my Lord, then this petition who has come to court under certificate of urgency, my Lord, having absented himself on at the Senate on Thursday for health reasons.
May I please?
I think that is okay. That is good.
My Lord, I'm just winding up, Lord, to emphasize the
But he did
contradiction.
not absent himself. Sickness is not absenting himself.
My Lord, I can rephrase. My Lord, I can rephrase. My Lord,
But
this
you can
petition.
as well avoid it.
Yes, my Lord. This petition.
My Lord, may I say he apologized.
Let him avoid it.
Yes, yes.
Let him
Yeah, my
avoid
Lord,
it.
I'm avoiding actually that.
Yeah, he has avoided it.
My Lord, justice administered without mercy and wisdom is not justice. Here you are talking about someone who is in his 60s, he's saying he's sick, he has cardiological problems, and you come and play it down. These are principal advisors to the government. They must be with them.
My Lord, can I now conclude?
Have you done that?
Yes, my Lord, I was making a contradiction by saying that the petitioner was able to access the court expeditiously, and the court was able to grant him conservatory orders on Friday. My Lord, the same petitioner cannot then come to court and complain. My Lord, complain when my Lord, the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, in public interest, and given the extraordinary nature of this matter, my Lord, gives directions that this bench be constituted for purpose of determining the underlying question. My Lord, the petitioner cannot probate and reprobate, can't speak on both sides of the mouth. So, my Lord, the other extraordinary nature of this matter, my Lord, is that the petitioners have filed a multiplicity of suits. My Lord, you have heard that there were 3 cases in Ongoya alone. My Lord, other cases were filed in Nairobi. My Lord, Kenyans, my Lord, this is the consumption of justice. My Lord, just a few days ago, the Chief Justice had appointed this bench to determine these matters for the satisfaction of Kenyans. My Lord, in the public domain, Kenyans are aware that this bench has been appointed. So, my Lord, what is wrong? What is so different? What is so strange for the Deputy Chief Justice when the Chief Justice is away, again for the same reason, for purpose of expediency and my lord, for purposes of laying a multiple basis for consistency in judicial decision making, for these matters to be brought before this bench by way of a direction in terms of uses being used of this matter. So my lord, I don't see anything extraordinary. My lord, as I wind up, the petitioners have just simply cast aspersions to the process of appointment. There's nothing cogent. Lord, I don't see any integrity issues with respect to the handling of this matter by the Chief Justice. I don't see any integrity issues with respect to the handling of this matter by the bench. So, my lord, our plea, my lord, our sincere plea is that the underlying dispute with respect to the setting aside of the conservatory orders, my lord, in accordance with the directions which were issued, should be urgently determined, my lord. My lord, in public interest. Thank you.
My lord, Madam.
Oh. My lord, for the respondent, I'll be very brief. I just wish to
remind us.
Yes, Dr. Kamoto, I think for the sixth respondent now with the new order. First, I wish to set the record straight. In terms of some misrepresentation that has been made with regard to the decision cited, the Reina Conchera decision. When the petitioners were submitting, they were not aware that I am one of the petitioners in this matter, and that I am fully versed with the entire set of facts. So they misrepresented that the matter is not active. Nothing can be further from the truth. This matter is active. It was mentioned on the 24th of September 2024 before a new bench that was constituted following the accession of the honorable judges who were previously dealing with it, and it is due for further mention on 30th of October 2024. So the decision remains solid in terms of its capacity to persuade you not to depart from it, because no reason has been supplied, save for the misrepresentation that it should not be utilized. Now, allow me, my lord, to make reference to the High Court Organization and Administration Act in light of the issue that has been raised on the sittings of the court. I will briefly cite verbatim Section 10 on the sittings and recess sessions of the court, where it is quoted as follows: that the court shall subject to subsection 2, 3, and 9 sit continuously for the trial of criminal cases and disposal of civil and other legal business of the court. There is no disclaimer whatsoever with regard to the time that the court should sit. So the court can sit at any point in time, day or night. Indeed, today, when dusk came, I was apprehensive that counsel for the petitioners might leave, since the court is sitting past working hours, presumably. So the point that must land home is that nothing prevents this honorable court from sitting at any time, such that then the issue of when the court sat, when the files were transmitted, when the orders were released, whether on Saturday, whether on Sunday, though it has not been shown that is what transpired, the court has liberty
to sit on such occasions if need be. With regard to the issue of the empanelment by the Deputy Chief Justice, again on this account, the petitioners have misapprehended the import of Article 165(4), because what is fundamental is that there be a substantial question of law, and that question of law is certified on the discretion of a High Court judge. What that means is that the same issues that are being had here today could have been had by even a single judge, if at the discretion of the judge who handled the matter reasoned that there was no substantial question of law. So what the Honorable Chief Justice or anybody else capable of exercising the powers within the office of the Chief Justice does is administrative. All the High Court judges are qualified to deal with matters of such nature. All of them. So assigning one or the other is routine. It is pure administrative. There is nothing that is exceptional intellectually in terms of requiring a special exercise of powers when it comes to dealing with that aspect. So in a nutshell, I would wish that, to point out that in a hurry to come to court, the petitioners even wrongly enjoined the sixth respondent, His Excellency the President, when Article 143(2) is clear that no civil proceedings can be instituted against the President. A decision that has been affirmed by the Supreme Court in the decision of Attorney General and two others versus D and 79 others. So the Supreme Court made an express order that the President cannot be sued. It's an order. So the pleadings that have been lodged before this court have been filed in contempt of the Supreme Court decision, and they should amount to nothing in the full and final sense of facts. So I'll be seeking that the bench continues to stay put, so that as early as possible, I can seek to have the sixth respondent discharged from the irregular proceedings initiated by the petitioners, and which they don't want concluded. They want to thrust this country into a crisis. Under Article 146, there is possibility of the office of the President becoming vacant on account of various issues, either through death, which is uncertain, through resignation, because he can tender a resignation and decide that I think I've had it too much, he can tender a resignation, or any other reason that may arise. So at the moment, upon the Senate voting on the first ground of impeachment, we stood without a deputy president. So what would happen in the event we have a vacancy in the office of the president? We are staring at a crisis. We don't have a deputy president. The Honorable Speaker of the Assembly can only serve for 60 days. We don't have an IBC. So what the petitioners are doing is fomenting a crisis of monumental proportions, which we will not be able to mind about. So I humbly pray my God, my lady, that you fight favor in the arguments of the respondents and dismiss the application by the petitioners.
I presume they are. But if they are over,
My Lord, we didn't clarify one thing. I think one of my friends have been referring to the judge at the right at Justice Murima. It's Murima.
Well, I grew up in Nakuru. I don't have the problem of a nail and an arm. So I know it's Murima.
Are you the only person submitting now on this?
Yes, I believe in my minutes, the 20 minutes, I want to do 15. There were 20 minutes, yes. And I said I'm doing 15. Mr. Ongoya will do 5. That's what I'm saying. He asked for 20, I'll do 15.
All right.
And Kaminwa, because of seniority, is asking for 5. No, my Lord, I have to use 15. There were very many people who say those things. So I need 15 and give Mr. Ongoya will need 5. Kaminwa 5. My Lord, let me start at least for one point. My learned colleague, Mr. Ndegwa, whom I respect a lot, is saying that probably we start with 2 points raised by a learned colleague, Mr. Joseph Kamodo. My Lord, the first thing, what is it? Okay. My Lord, the first thing is that the president cannot be sued. My Lord, for purposes of my understanding of the Constitution, everyone under the Constitution of Kenya is subject to the law. That is what the Constitution says. There is nothing the Supreme Court or any other court can say as valid law to change that position of the Constitution. So to the extent that the Supreme Court, assuming it ever says such a thing, that cannot be good law in the face of the Constitution saying everybody is under the law. Second point, my Lord, what is the nature of the proceedings? These are not civil proceedings. These are constitutional proceedings. If Article 149 of the Constitution says the president shall do this, there is nothing in Article 156 that would entitle the Attorney General to be sued on behalf of the president, because the Constitution itself says the president shall do this. My Lord, also, if this is Bill of Rights enforcement, if the petitioners are saying the violator of the law is the president of Kenya, then the mandate of this court is to ensure the president does not violate the Bill of Rights. Nobody else can be sued on his behalf. I think we have done with that preliminary issue. Oh, and there is these issues of vacancy. My Lord, I was imagining that if this vacancy is troubling anybody in Kenya, 2 things. Number one, you would have seen some urgency in reconstituting IEBC. Some of the petitions that are before you, or that will find your way to your hands, are also saying the president cannot do what is so desperate to do because there is no IEBC. So that is coming. So if there was any urgency, anybody who cares about vacancy, let us start with IEBC. My Lord, also, if, and I think Kenya are entitled to this information, Mr. Kamodo appears sorry that a vacancy in the office of the president may arise. Perhaps this is information the people of Kenya are entitled. Why is that so?
Well,
I'm not saying anything. I've ended there.
Unless you have some.
I don't know. I did say it. I did say it. Yes, my Lord. Now coming to the main issue. My Lord, this forum, somebody said we are sitting past the desk. It made me remember something. I think I saw the presiding judge was practicing at some time when I was practicing as a lawyer in the 1990s. And I remember going to court many times with Dr. Minua, Paul Muite, and Gibson Kamau Kuria. What was it all about? My Lord, during that time, and when we could go to those cases, there was no distinction that was made.
My Lord, with your very kind permission, I'm constrained to just want to get some clarification. Are we re-urging the application?
No, I'm
because
responding.
the role you have as in Illinois, you are supposed to be responding to issues that have arisen. I don't think what you're speaking to has arisen, and there is no latitude that extends to that direction. My Lord, we stand. We would want to get some guidance.
My Lord, I believe those
Mr. Kid, you gave the clarifications earlier,
yes,
but now just stick to the reply according to that.
I'll do that. My Lord, one of the cases that during that time, because you know we can't address the literal issue. I'm trying to be global. My Lord, one of the, and these are global points I'm making with regard to the issues that have been raised. My Lord, you are effectively being told the petitioner and the respondent occupy the same space from the standpoint of our constitution. My Lord, the truth is they don't. And I say that for the simple reason that these constitutions of Kenya was made explicitly to protect citizens who can suffer from harm from the executive and people who occupy power. That is what the protections are meant to do. Conservatory orders are given to ensure people whose rights are being violated and in need of protection, that protections will be accorded. So somebody to say that an application for conservatory orders stays on the same level with an application by a violator to continue or to complete the violations, my Lord, that would amount to misreading the Constitution. And this is not an idle issue. Under Article 20, it is very clear. The Constitution binds all state officers and this call. So the notion that we have a right to be heard, yes, when we shall be doing the petition, give them 10 hours and we shall not object. But let the subject matter be preserved. We've got no problem. The right to be heard under Mutunga rules is protected. But there is a distinction under our Constitution between a violator and the victim of violation. That one is very clear in our jurisprudence. Well, having said that, there is another office. There is a question of the empanelment, whether you call it assignment, appointment. The issue is, for purposes of Article 165 of the Constitution, does the Chief Justice exercise judicial or administrative powers? I go with what Dr. Kaminwa says. These are judicial powers. And judicial powers, my Lord, takes us to the oath that is prescribed by believing the that schedule of the Constitution. When the Chief Justice says, takes an oath, is to exercise the judicial powers that includes, with regards to the High Court, the powers under Article 165(4) of the Constitution. No such oath is taken by the Deputy Chief Justice to enable her to do so. So that, my Lord, as long as, if you say it is administrative, we go to another level. The questions would be, can this be made without a formal judgment where the issue has arisen directly? Because as we were told by my learned colleague, Mr. Waduta, that matter is still yet to be decided by the Court of Appeal. My Lord, having said that, there's a question my learned Professor Muigai, whom I learned a lot from him. My Lord, Professor Muigai talks about public interest, the issue of the necessity for it, and about a vacuum arising. My Lord, the happy thing about the Constitution is that up to this time, the petitioners have done nothing that would elongate the time at least of 74 to 100 days that is envisaged under Article 149 of the Constitution for this business to be conducted. If anything, it is this kind of applications to set aside that will prevent these petitions from being heard, for example, in the next 30 days, so that there is still some other 30 days for the people of Kenya to be consulted on this issue and the regular decisions to be made by Parliament. My Lord, there is an issue that an absurdity is being created. Who is creating an absurdity? The absurdity, my Lord, that is being created is this. And strictly speaking from Article 25 of the Constitution. Article 25 of the Constitution says the right to be heard is absolute, even during an emergency. How can this right ever be absolute, and this court were to take away the subject matter before that right is exercised, and you do not call that an absurdity? We are actually here to prevent that absurdity. In fact, you can have a ranking of absurdity. The biggest absurdity, my Lord, would be this, Article 125. All rights under Article 24 can be limited. Under Article 25, the right to be heard is absolute. It is binding on everybody. That's the biggest absurdity that can occur. Who supports that absurdity? The respondents. My Lord, we go next to Professor Ojienda. Of course, Professor Gedu said many things which you cannot deal with all of them. This internal memo, where is it? Oh, it's here. It's here. My Lord, this internal memo, first of all, we note, when the question was asked, is it anywhere? It is not in the CTS. Start with. Number two, or portal for the cases that have actually been filed. My Lord, the second issue, there is no reply affidavit for this court to be able to deal with it. But what does it actually say? It says, during my absence, I request you, your lordships, to be in charge. I will, however, be available on email or telephone for consultation. My Lord, the last sentence, plain meaning of English, would mean to me that Chief Justice from Geneva or anywhere else she was cannot be able to carry out certain administrative functions. But when she says that to be consulted, this was clearly made in the knowledge that there are certain things that I must do, notify me so that I can do them. The appointment of judges could be made by the Chief Justice in accordance with the constitutions from Geneva. My Lord, I could have said more, there is no much time. My Lord, they say they are challenging ex parte orders. My Lord, what ex parte orders is the main issue. The ex parte orders we are challenging is a conservatory order to ensure that before this court, there will be integrity and the constitutions will be upheld. And the kind of circus we had in Parliament will not happen before you. My Lord, my Lord, for purposes of where do we want this matter to be completed? My Lord, they said this is that they want the matter to be completed. We are more desperate for this matter to be completed. And that is why in the expectation of the petitioners, we expected that the first business of this court, like it happens every time I sit on benches, and I've sat on very many, they say, this matter is very urgent, we cannot hear preliminary matters, let's go straight to the petition. So we are very desperate to have this matter heard. My Lord, there is my learned colleague, Mr. Nyamodi, whom again is a good friend of mine I respect. CJI occupies 3 constitutional offices, I agree. But the only issue of distinction is, under Article 165(4) of the Constitution, she cannot be able to perform that function any more than we could say she could transfer judges. Transfer of judges is actually more or less administrative, but she doesn't do it because it is an important office that goes with the office of the Chief Justice. But if this is judicial, she cannot be able to do it. My Lord, the issue of Conchela, again, the issue is contextual. The Chief Justice was a party, and therefore in Conchela, as far as I am concerned, the matter, the Deputy Chief Justice did so as an acting Chief Justice. Even Gachagua or anybody else who gets into that position, when they are acting as acting president, there are certain decisions that they can make, but they must wear that position. In this letter, there is nothing that suggests that the Deputy Chief Justice was turned into an acting Chief Justice by the CJ. Equally importantly, there is no express delegation that my powers under Article 165(4) would now be performed by the Deputy Chief Justice. My Lord, the issue of Gumbo came with some funny issue on concealment of material facts. I do not know. I struggled to listen that we have concealed anything. Now, as anything, we actually even did an affidavit. We had a right to do an affidavit. It is not indicated that this document, which was in our possession, as I understand the law of disclosure, we failed to disclose it. All the other issues they are raising are points that are in contention. That does not amount to concealment, as I understand it within the law. My Lord, there was the question that no basis for Getonga Murugaros. Getonga Murugaros, I'm trying to rush. Murugara. Oh, that's very sorry. Oh, that's okay, my friend. My Lord, he says, and I agree with him, that this matter is very important for the 50 million Kenyans. I could not agree more. A matter that is so important to 50 million Kenyans, the least that could be expected is that proceedings are going to be conducted in open, without suspicions, without undue hurry and pressure. But my Lord, if the petitioners, and already they are feeling, I'm feeling pressure that I started to do, if the petitioners feel that they are under pressure in a certain matter, that is not an expressed emergency under the constitutions of Kenya, it leaves a big question mark. If for some reason there is a desperation to turn businesses that the constitution says you should do it within around 80 to 100 days into 4 hours, there's a big problem, and that must be addressed. I'm about to finish. My Lord, so that for purposes of those issues, I agree with him. It just points out to the care that must be taken that these proceedings are not misunderstood. This court in particular must not be understood that it was under undue influence, that we must wear somebody Wednesday, Thursday, or something like that. This must be done within the 4 corners of the Constitution. If that one is not done, my Lord, there would be a huge problem, not just of perception, but the huge problem that in Githongori versus Republic, they were talking about. The world, Africa, and everybody else is watching. And what are they watching? How are we going to consider to reduce time, for example, that is expressly set out the Constitution into hours? And to do what? To prevent a victim of constitutional violations from urging petitions that are before the court. That should worry the court more. 2 points that are remaining. Mr. Wanyama, I have to choose between Wanyama. Oh, Wanyama is the last one. My Lord, the issue of Wanyama is national stability. He made several points. That is probably the only one I will address myself. Ms. Ongoya can do the rest. This issue of national stability is actually very important. I agree with him. The issue of the impeachment of the deputy president raises the issue of national stability. For the simple reason, and this is why we must hear the petition, the deputy president, my lords, and as we understand elections in this country and the Political Parties Act, was not just a holder, the way you can appoint Kibemongai to be a legal officer somewhere. He was not just a holder of the office of deputy president. There was a political process in order to be able to get power under the constitution in the 2022 election. That's why the national issue of national stability arises. His supporters and also the president, they came together to form a party. So that, my Lord, over and above, and there is a case which I was privileged to do in 2013, one of the lawyers in that case, this one of conflict management, when Ruto and Uhuru were being prevented from running for presidency in 2013. That case, my lord, and we did it before 5 judges. It was civilized, it was decent, there was no hurry. But more importantly, what was the issue there? Part of the issues that I was present in that case to urge is that President Uhuru and the now President Ruto are not seeking this case by themselves, because Article 38 of the Constitution says they are doing this. The people's in exercise, their supporters, in exercise of their right, political rights, and Article 38, prefer these people to be their candidates. So what's my point? My point is this: look beyond Rigathi Gachagua. Look also to the people who feel we've not been given a square deal and we are being disenfranchised, we are being emasculated from the political scene. We shall urge that more during the hearing of the petitions. For now, let us hold the ring. Let us not take away the ring so that we can meet sometime next week and deal with the issue. My learned colleague, Mr. Ongoya, can take it from here. No, my lord, I have finished. My learned colleague, Mr. Ongoya, will say something.
My lords, my lady, I just have a few points to highlight. There's a question by Dr. Kamoto on misjoinder of his clients. Let me just make a simple point that to the limited question whether the DCJ can constitute this bench under Article 165 Clause 4 of the Constitution, the question of joinder, misjoinder, non-joinder is absolutely irrelevant. There's no bearing on that question completely, and that would be a straightforward answer to that issue. Mr. Kamoto also said that this court can sit on any day, at any time, continuously. Section 10, subsection 7 of the High Court Organization and Administration Act 2015 does not support his argument. That section provides, and I quote, the Chief Justice may, where necessary for the expedient and proper exercise of judicial authority, authorize the sitting of the court on any day or at any time. The sitting of this court on any day at any time requires express authority of the Chief Justice under Section 10, subsection 7 of the High Court Organization and Administration Act. My learned colleague, Mr. Nyamodi, made an important point, and I think I support that point. The Constitution says what it says, but it means what the court says. Very crucial point. The Constitution at Article 165, Clause 4, says who can constitute this bench. That is the Chief Justice. Can the DCJ also do it? Is that an administrative or a constitutional mandate? The jurisprudence by this court, as we have alluded to, is 3 cases: the Omtata case, the Kemri case, and the Leila Conchela case. The Omtata case and the Kemri case present that as a constitutional mandate of the Chief Justice. The Leila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues from the other side. Since I have only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Jenda presented a piece of paper from his hand, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no timestamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said, Mr. Nyamodi will comment on it. Mr. Nyamodi stood, began, and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this would find themselves in the file through affidavit. This evidentiary material, again, we were not told which affidavit or which deponent filed on which day. We would therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge my lords that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution, to give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters that is where a question of principle arises, and of all the three organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to admit that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.
My Lord, I'm a full-time lawyer, full-time. I appear in the Magistrate Court, High Court, Court of Appeal, and I appear before what you are arguing here is a matter of law. It has absolutely nothing to do against any of you, either individually or collectively. So we are arguing this matter as a matter of principle, saying that things have not been done properly. And it's because, my Lord, and my lady, Kenya is an interesting country. There is a book here which I read from time to time. The Constitution of Kenya Commentary. The Constitution of Kenya Commentary. There is a section in this book which is very interesting. It says, and so I came today to this matter, I would have been able to go through and flag a particular sentence. There's a sentence which says this. Kenya is one of the most corrupt countries in the world. In this book, it's written there. Kenya is one of the most corrupt countries in the world. And my Lord and my lady, suspicions are cast on national security. Suspicions are cast on the Senate. And my Lord, we appear before the Lord. When suspicions are cast on this court, we stand up and protest loudly. All that you are arguing respectfully. My Lord and my Lady, let this matter, when I quote what the man said, let this matter go back to Chief Justice. If he endorses you, he recommends you, we have no problem. She have done her work properly. But let things be done in a proper manner so that we do not send out the wrong signals, so that we do not send out the wrong perception that there is corruption going on in National Assembly, in the Senate, and in the judiciary. let the matter go back. Now, it was said to you that there are certain individuals who are above the law. That's not correct. When you are appearing before the lordships and my ladies, we should show that actually we are really violating the law. All of us, as the land friend, is a keeper point that quite properly. All of us are under the law. The judges are taken to court. The chief justice can be taken to court. The speaker can be taken to court. The president can be taken to court. And in fact, the case of Trump versus Vance, a United States court, 9 Supreme Court judges made it very clear that the director of criminal investigations is at liberty to investigate on the president of the United States. It's my humble submission that we shall be advancing the same argument. That in this case of Gachagua, no director of criminal investigation was called or summoned to give evidence. Am I wrong, Mr. Mr. I'm right. Thank you. I'm glad I'm still right. No director of criminal investigation was summoned to give evidence. This is a lacuna. This destroys the whole case. My Lord, there is something else I would like to say to you, very, very respectfully. Conflicts at work. We are always quarreling with people we work with. It's normal. I happen to know that Chief Justice Miller and Sir James Wilkes never got on very well at all. They quarreled from time to time, but they couldn't work together. I happen to know Chief Justice Trevedian and Justice Martin were not friends. They used to throw some things against one another, but they continue to work. Some of us who have been married and so on, we know that actually at times a wife can quarrel, and at times a man can quarrel, but they still continue to live together under the same roof to make sure that the children actually have a parent, father and mother. And that's what we are saying. This nation has to survive the crisis. We cannot destroy the nation by saying because the president and deputy president quarrel. That is very, very naive way of looking at life. Thank you very much. And I shall be advancing the arguments of alternative dispute resolution. I put them on notice. If you are advancing the notice, the alternative notice dispute resolution, you can get President Rigathi, we can get our archbishops, we can get our retired Supreme Court judges to sort them out and continue to work. But we cannot abandon the Deputy Chief Justice because the two of them cannot get on well. That is a very, with respect, that's a very childish way of approaching this. Thank you. I have a book here that can donate to you. And a presidency.
I have it also.
Oh, thank you. Yes. May I say, I'm very happy that you are such a great so widely.
I always do. So Senior Counsel Paul Muti, are you responding?
No, in the interest of time, I will go along with the submission.
Then we can give you 1 minute.
Yeah. Just 1 minute.
Your name again?
Yes, Kimoto Teresio and Jiro Makazi. It says Kimoto and Company Advocates, Ongoya. Yes, I wish to respond just briefly on one issue. That is the issue of service. There was an issue raised that the notice was not necessary. And we insist that because today was inter-parties hearing, then the notice was necessary. We also wish to say that one can do a good thing, but at the wrong time. And the reason why we are saying this is that the Chief Justice, though we are being told, you have been given a memo and directed to the portal, which I have checked right now, and it's not there. The last thing that was there was a ruling delivered by Honorable Chief Richard Mwongo at Ongoya, and there's nothing else. So the Ongoya matters, they have nothing else there. And we have been told this internal memo was filed as petition E14 of 2024. So that is not true. However, we wish to say that once a court sits on Saturday, and then at a wee hours, it could look like a good thing, but then a wrong thing. Because the perception people will have is that there's something fishy going on. That is what we are crying out loud and saying it is not necessary. And the last thing that I wish to note is that justice cannot be served expeditiously while infringing the rights of others. So we are very much in order. Fair hearing is a must. And we cannot be told it's for the interest of quick delivery of justice that we infringe other people's rights. So we are saying, let us be heard fairly, and we be given enough time to respond to all the motions that are before court, and also the petitions or the responses filed, so that we cannot be prejudiced. That's all.
Your Lordship, with your very kind permission, my name is Akimpa. I just have one issue to respond, and that is by Professor Rigathi on, Your Lordship, Professor was so precise as to the time when the file was transferred from Ongoya. That is at 3:45 p.m. Your Lordship, I have also taken the liberty to look at the order that was issued in that matter. And it was, the order was issued at 3:37 p.m. So in 8 minutes, Your Lordship, the petition E015 was transferred, or rather was transferred to the Chief Justice. Your Lordship, in our matter, that is petition E014, it was transferred to Her Ladyship on 11th of October. So those are 8 days. Your Lordship, therefore, we don't understand why the expediency that came in the sense that one petition is transferred to the CJ in 8 minutes, while our petition takes up to 8 days for it to be transferred.
I think the petition which was filed in Ongoya, the lawyers who did that yourselves,
yes, Your Lordship,
should answer that question.
Your Lordship, and that's
Yes, that is your question to answer. You cannot post it to us.
Your Lordship, it's in the context of the matter in which.
Yeah, you must balance all issues. You don't, when an issue favors you, you want to raise it up. When it doesn't favor you, you want to put it down.
I'm well guided.
The orders which came from Ongoya were your orders. Thank you very much.
Thank you.
Thank you very much. Before we make final orders, please keep quiet. Before we make final orders, we as a bench, we want to thank all council for the mature way in which we have conducted today's proceedings, and the legal arguments which we have put. We are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Leadership, perhaps before you turn off, there could be a possibility, Your Lordship, that it is imperative that we have the other files that were not before you coming up for a mention tomorrow, because there is an application for your recusal that I have filed. I would perhaps also wish to seek directions on it.
May it please the court. Once more, my name is Dr. Eboso, and I'm still beseeching the court that there are other petitions that were filed on this same matter, and which applications were made, including temporary injunctions, but which were not given, and which it would be good use of judicial time if the petitions and the applications therein were heard together with the applications that are in this matter. And I would like to point out that if this bench, which is a high court, proceeded to hear the issues that surrounding the conservatory orders in this application, the three applications that are before this bench, absent the participation of the applicants in all those other files which have already been filed, we would suffer prejudice because we would be arguing applications after the court has already sat, and we would be reinviting the court to argue the very same thing. So I would wish, as the court retires, to consider that. Thank you.
Okay. Maybe before the non-AG addresses, I just want to make this clear again. We will not deal with any file in which we have not been empaneled. If you filed a petition and it is yet to be empaneled, it is upon you as counsel to follow it up with the deputy registrar of the court. First of all, we have to ascertain whether you applied for empanelment, because it's not automatic. If an order for empanelment was made, follow it up. That is the only time you can know what happened. When the file is empaneled, it comes before us, we will deal with it. For the matters which were empaneled, and maybe they are not here, we presume they are not before us because we were not moved. We have handled the matters today because we were moved by an application. If you feel we need to look into that matter expeditiously, you may have to consider. But at the appropriate time, we will issue comprehensive direction on all the matters which were paneled with, which we were paneled, even if there will be no applications. So let us get it clear so that as we move forward, we avoid this back and forth of getting us back to matters which were either paneled or not paneled. Let's be focused. We will deal with every matter, but now we're dealing with matters where we have been formally moved. Thank you.
Yes. My Lord, very well kindly, and we do thank you for holding the flag of justice for all.
Your Lordship and my lady, on behalf of the respondents, I want to thank you for according us orders this afternoon to this evening. I want to thank you for your patience. And as the tutor head of the bar, I want to encourage my learned friends that we must continue being respectful, professional, and holding the dignity of these courts very highly, and protecting the dignity of the courts and the dignity of our country. Thank you so much, and have a blessed evening.
Thank you.
Madam, may I, sorry, I like talking. Madam, may I say that I am most grateful to the remarks of the Honorable Lady Attorney General. And if I may say so, with respect, in the most recent times, she has shown that the courts must be respected by herself personally appearing in court. There are some previous attorney generals whose name I would not like to mention, but who are full-time office workers.
We reconvene tomorrow, the 23rd of October at 3:30 p.m. Thank you.
Let's see how it goes.